Welcome to this episode of Mayor Brown's Quick Insights on Congressional Investigations with Michael Levy and Andrew Ullman. Our 5-minute perspectives for in-house counsel and government affairs executives on the most important and challenging issues surrounding congressional investigations. I'm Michael Levy, a white-collar defense lawyer at Mayor Brown. My partner, Andrew Ullman, is a former Republican chief counsel of the Senate Banking Committee. In an earlier episode about how to handle the media in congressional investigations, we said we'd probably need to do another episode to cover the topic, and we do. So to look at that question from a different perspective, Andrew and I decided to ask the question, should you get your story out in the media before you testify at a congressional hearing? Andrew, what are your thoughts?
Well, my strong general rule is that you should not engage in any media, which includes social media, blogging, as well as traditional written media and TV. Now, there are exceptions to this rule, and the particular facts and circumstances of the investigation really matter when you're deciding whether or not to engage the media, which we can talk about. However, the default position is not to engage with the media, and let me give you 3 reasons why. The first is that, as we've discussed, in the vast majority of cases, requests from congressional investigators can be worked out with little difficulty or after reasonable negotiations, which means that there may not be the need to actually have a hearing in the first place. However, if a client or their attorney goes on TV early in the negotiation process before even a hearing is announced, or otherwise resorts to the media, it could make it more difficult for a reasonable compromise to be reached. Once a client takes a public position, right, it limits the areas where compromises can be reached and creates increased reputational risks if the matter is not resolved in the manner the client wants. It can also cause congressional investigators to firm up their positions, as they now know that their negotiations are likely to end up in the media, and they may feel that the client breached trust with them and is no longer working with them in good faith. As a result, congressional staff may decide that a hearing is needed when it actually could have been avoided with a more cooperative, low-profile approach. Second reason is that you cannot always control the media. And tell you, let me give you an example here. Say the client decides to go on TV and makes what they consider to be the best case for their position. And they feel that they've made given a fantastic interview that fully justifies their conduct. You cannot control how that interview will ultimately be used by the media. You cannot control when it will be broadcast. Will it be broadcast? Which parts of the interview will actually air? What types of commentary or other reporting will frame the interview? As a result, an interview that the client may think was perfect could actually turn into a real liability when it's aired and undermine their position or argument that they're going to try and make in the hearing, and may take the hearing down a much more adversarial approach. And this leads to kind of the third reason not to engage the media. When a client talks to the media, it opens the doors for others to provide their views of the situation. Now, this would include not only members of Congress who are involved with the investigation, but also media commentators and interest groups. There are plenty of people out there who are more than happy to share their views on any public event, and who are often very happy to explain to the public why your client is wrong. And this can needlessly escalate the stakes of a congressional investigation, and particularly on a hearing, turning what could be, say, a low-profile, kind of routine congressional hearing, and turn it into a much larger public affair, increasing the reputational risks and other risks to the client. So that's why those are my 3 main reasons of why normally I think going to the media is something that is not a good idea to do. But again, there are occasions when a client should definitely consider resorting to the media. But I think any decision needs to be well thought out with the advice of counsel, and any media appearance should be carefully selected and diligently prepared for.
I think that's exactly right. You for the most part probably don't want to attract more attention and more media attention to a situation that probably isn't terribly helpful for you. But I like to always say that the conventional wisdom is conventional because 95% or more it is right and it's the right strategic call. But a huge part of the role of good, experienced lawyers is to be able to make smart assessments about whether the particular situation the client is in warrants a different approach somehow. And I think it would be rare, but I could imagine a situation, for example, where a very well-known person in a matter that's already very public, where the public narrative is already becoming so toxic that you could make a reasonable strategic choice deciding that it can't get any worse than it already is. And if you actually have a narrative, you have something to say, and you can find, as you correctly pointed out, the right outlet to say it, you could find you find yourself in a situation which all of the risks that you described might be worth taking. They're still there, but you could take those risks in exchange for the possibility of just starting to shift the narrative in potentially a slightly more positive way. And you also might be able to take some of the sting out of what's likely to happen at a congressional hearing by previewing it on your own terms and in a forum of your choice. So you would incur the wrath of the members of the committee, as you said. Often that's reason enough not to do it, but every once in a while, it's certainly a strategy worth seriously considering with your client. And even if the client doesn't do an interview, it's worth considering whether others, either on or off the record, can start to build a different narrative with the media in advance of the hearing. The members are going to be building their narrative in advance, so it may behoove you to try to find a way where you can build your narrative in advance as well. With that, thank you for joining us for this insight in this episode of Quick Insights on Congressional Investigations. And if you want to watch any of our earlier episodes, you can find them all at mayorbrown.com/congressional investigations videos. Thanks.